Parker.com/murderousminors today and get started on your way to the perfect accessory for the stylish contemporary. And when you do, let me know which ones you pick. Colleen Ritzer was a beloved educator within her community and was publicly mourned. She was a 2011 graduate of Assumption College and was working on a master's degree in school counseling at Salem State University when she was murdered. Students and peers found her easy to approach, and she was known for her dedication to helping kids who needed it. Colleen always wanted to be a teacher and had a particular enthusiasm for math that she loved to impress upon her students. She often used her Twitter account to connect with, engage, and encourage her students.
Sadly, Miss Ritzer's final tweet was about Monday's school shooting in Nevada, another student allegedly killing a math teacher there. Ritzer called it simply devastating. At Game 1 of the World Series, a moment of silence in her honor.
She was a dynamic, brilliant daughter, friend, and teacher remembered for her wide, ever-present grin and love of the color pink. Philip remained in custody, awaiting trial at the Metro Youth Services facility in Dorchester, Massachusetts, where in early June he made news once again. He was charged with a sneaky attack on a female staff member whom he allegedly restrained with a sharp pencil, the only weapon he could acquire. According to his indictment, Philip removed his shoes in an effort to silence his steps. He went so far as to crouch down and shuffle unnoticed low to the ground and into the bathroom where the assault took place. The victim was able to remove Philip's hands from her neck long enough to scream as he then pummeled her head with his fists. A male staffer was alerted to the scene and intervened, seemingly just in time. On July 9, 2014, he was charged with attempted murder by strangulation, assault with intent to murder, kidnapping, and assault and battery with a dangerous weapon. He was indicted as a youthful offender, not only exposing him to the same penalties an adult in his position would face, but also making details of his case open to the public. He was ordered held on $25,000 bond, and his attorney, Denise Reagan, requested he be exempt from his next scheduled hearing, as it would cause him too much stress. Proceedings toward his murder trial in the death of Colleen Ritzer continued on, and on March 3, 2015, Judge David Lowy suppressed some evidence. Although he would not allow into evidence the confession made to police or cell phone evidence gathered from Chism and Ritzer's cell phones, he did, however, allow the contents of the knapsack and Philip's pockets to remain admissible against the wishes of the defense. The defense made an unsuccessful attempt to have the unnatural rape charge dismissed, and jury selection began. He was to be tried as an adult. Questions regarding Chism's mental competency delayed jury selection, and a psychologist testified that he had made reference to hearing voices during an interview. Prosecutors alleged he was faking in an effort to stall. Earlier that week, Philip had refused to enter the courtroom and overheard proceedings from an adjacent room instead. A mental competency evaluation was ordered, and trial began in Essex Superior Court, Salem, Massachusetts, with his attorney admitting that he had killed Colleen Ritzer. She contended, however, that he suffered from severe mental illness and should not be held criminally responsible for his actions. She referenced a rage disorder diagnosed at the age of 10. The very next day, on day 2 of his trial, he once again refused to enter the courtroom after a short recess had been held. Defense experts continuously tried to point the finger at a rage disorder. However, the prosecution experts presented the opposite view. On December 15, 2015, he was found guilty on the murder and on one rape charge and was acquitted on the unnatural rape charge. The prosecution found themselves unable to prove beyond a reasonable doubt that Colleen was dead before she was violated in the woods with the branch. Chism was therefore acquitted on the second rape charge, one count of unnatural rape.
Colleen Ritzer lived a life of quiet heroism. That's what most teachers do. The defendant, Philip Chism, did not start life on third base. The court points this out not by way of excuse or even explanation, but because it is true. Sometimes his father was living in the family home, sometimes he wasn't. Although the defendant's father was not present during the trial, his presence was still palpable. He was abusive, harsh, unfaithful, and unpredictable. The defendant's mother worked hard to provide for her family, emotionally and financially, with mixed success. While the extent or lack of extent of the defendant's mental health was the subject of exhaustive testimony at trial, the Commonwealth presented overwhelming evidence that the defendant had substantial capacity to appreciate the wrongfulness of his conduct and had the substantial capacity to conform his conduct to the requirements of the law. The jury found that the defendant killed Colleen Ritzer and that he was criminally responsible for her murder.
Essex County Sheriff Frank Cousins referred to Chism as a very dangerous individual who required constant watch. He continued to be held at the juvenile facility and was basically kept isolated as he awaited sentencing scheduled for January 2016. He refused visits from his mother regularly and was only permitted to meet with his lawyers when shackled. He would move to state prison at the age of 18. At sentencing on January 26, 2016, Chism received 25 years for brutally murdering Colleen Ritzer, the maximum sentence a juvenile could receive for first-degree murder. He was sentenced to 40 years and 1 day for Colleen's rape and robbery. His sentences are being served concurrently, and Chism will be behind bars until at least the age of 54.
This court will impose the mandatory life sentence for the murder of Colleen Ritzer and set a parole eligibility date of 25 years, the highest level our law allows. This court will impose a concurrent sentence of 40 years to 40 years and 1 day for the rape of Colleen Ritzer and a concurrent sentence of 40 years and 1 day for the armed robbery. In imposing a sentence for the rape at a date in excess of the parole eligibility date for the murder, the court is not suggesting that the rape was more egregious than the murder. Rather, this court is constitutionally obligated to set a parole date no more than 25 years for the murder committed by a juvenile. Sentence may be imposed.
Sir, you stand committed. Custody, Mr. Officer.
All rise. Court is in recess.
Philip Chism's expression belied no emotion, in stark transition to the raw feelings exhibited in the 9 victim impact statements allowed read by the court. On October 18, 2016, the family of Colleen Ritzer filed a civil suit intended, according to their attorney, to generate funds to safeguard against possible future crimes on campus. The main purpose of the lawsuit, according to the Ritzer family, is to determine how and why the so-called state-of-the-art security system failed to alert anyone in the school that this horrific crime was unfolding. The town of Danvers, the Danvers school system, the janitorial company SJ Services, along with Danisco Design Partnership, the architectural firm responsible for design and implementation of the school's new security system, were all named in the suit. The system had been touted by Danisco as one that would ensure the safety of both teachers and students. 1 count wrongful death was charged against Danisco, along with 1 count negligent infliction of emotional distress, with which the town of Danvers and Danvers public school system were also accused. The wrongful death charges allege that the direct negligence of Danisco resulted in Colleen being vulnerable to Philip Chism's stalking and attack. Danvers High School resource officer had testified during trial that he had repeated issues trying to access and navigate through the surveillance footage as he searched for clues about Colleen Ritzer's whereabouts. He stated that he was unable to view the footage chronologically or by order of location due specifically to how the system was installed. The main computer used to access the system froze repeatedly as well. 1 additional count of negligent infliction of emotional distress was filed against the town of Danvers, Danvers Public School System, along with SJ Services, in an attempt to connect the unnatural rape acquittal with negligence on their part. An SJ Services employee had testified during the trial that he did go to the facility's supervisor on duty to alert him to the suspicious scene. However, he admitted that the language barrier played a factor in getting his point across. The janitorial supervisor who testified said that he saw bloody footprints outside the bathroom door. Inside, blood covered the area from just inside the door straight ahead to where the handicap access stall began. All 3 stalls to the right had blood on their floors. The lawsuit contended that elimination of this evidence led to a prolonged period of investigation. On Thursday, August 9, 2018, nearly 2 years after the suit was filed, all parties were in court as the subjects petitioned to have the suit thrown out. The attorney for the janitorial service stated that his client's employee did his job, which was to clean the bathroom. He also pointed out his attempt to bring attention to the blood. The Ritzer's lawyer contended that his actions prolonged identification of the bathroom as the scene of the crime, and therefore that of determining what happened to Colleen as well. Danisco's attorney Mike Stone, whose client designed the 140-plus camera security system, contended that the cameras too did their job. The evidence they ultimately provided, whether in the correct order or not, was essential to the investigation, he argued. The attorney and the judge volleyed back and forth whether having a designated individual in place to monitor the cameras may have prevented this tragedy. Danisco stated it was not their decision how the school chose to use the equipment and that they're only responsible for designing and installing per the client's wishes and contract. After all parties spoke, the judge, Jeffrey Karp, urged them to consider court-supervised conciliation services as opposed to a long, drawn-out trial. He then let them know that he needed time to refer to case law before he made his decision. On September 25, 2018, Judge Karp ruled that the janitorial services, the school's architect, and the town of Danvers were not liable in any emotional distress experienced by the Ritzer family. However, he did determine that the negligent design and implementation of the security system as a whole was a substantial contributing factor in causing Colleen's death. A statement made by their attorney on behalf of Danisco reads, "The video monitoring system included in our firm's design for Danvers High School met all specifications set forth by the town of Danvers and its police department and is considered best in class for its purpose. As the architectural firm of record for the project, our contract was specific and exclusively limited to the design of the surveillance equipment. It did not include staffing, personnel, or monitoring of the system. At the time of the incident, the system was working as designed and the video surveillance system was an integral factor in assisting in the prosecution and conviction of the murderer." The wrongful death lawsuit against the design firm is ongoing, and I will update the story when proceedings conclude. In regards to the attempted murder by strangulation and other charges stemming from the attack on the juvenile detention employee, Philip Chism, now 19, awaits trial. Although attempts were made to resolve the case without going to trial, efforts weren't successful and the slow trudge continues. It seemed that the defense planned a solid insanity defense at first. However, after a competency evaluation, proceedings continued as though he were indeed competent, although the results weren't disclosed to the public. I'll update this case too whenever sentencing has taken place. In Colleen Ritzer's memory, pink-clad runners can be spotted once a year at the Step Up for Colleen 5K. The race and other fundraising efforts benefit the Colleen Ritzer Scholarship Fund. Recipients are graduates of Andover or Danvers High School who possess values similar to Colleen's and wish to become educators. Thanks for coming back. See you soon for a few chilling tales of boys who acted with no regard. But until then, don't be scared.